130, Your Lordship. From 69, 89, and then 130, Your Lordship.
We'll have it on Monday. Monday upar kar do. Yes, it was mentioned by DSG on Friday also.
But I mentioned,
It is a WPST.
Your Lordship, it's a FME, first miscellaneous MAT,
So what is it?
Group 6 matter.
What is that day? Monday.
Monday, Tuesday, Your Lordship takes. Sincerely, Your Lordship.
Item 6, my lord, my learned friend is 6. My learned is appearing for the petitioner. My appeal for the stay. The matter was dismissed for default on 22nd August 2023. Thereafter, I had to submit all the papers to the department because after dismissal. Now, my lord, you have to register the matter, but now my learned friend is to file 2 copies of the application before the department, my lord, so that it can, advocate can be engaged in this matter. I mean,
But my learned friend appeared at the time of when my lord is pleased to restore the matter.
because after
So
restoration,
when it is taken up, just wait 5 cases. Why can't you wait for 5?
because my 2 p.m. matter, special bench constituted for taking Ponji bench. I am the sole advocate to appear before the.
All right, we'll consider what you have said. Don't worry. Let it be called. Some order will have to be dictated.
But yes, ma'am. My last is to file 2 copies.
Ask someone to be here. Any friend to be here. Yes.
No.
You do bolo diyo. But I am the people the special bench for the Ponji matter.
When we look at him, we see the state government. Yes.
So first time no problem. But now I have.
All right. Don't worry.
My lord, in one of the matter, my lord, you just already decided for disposed of. That is on 4 February 2016. Of this month, my lord. The order has yet to be uploaded in the website.
Which order?
1471 MET 1471 2019.
Just see. Don't note what is. Make a note. We'll see. No, upgrade. Yes.
Item number 1 for judgment.
Yes.
I am for the writ petitioner 81.
We are allowing the writ petitions. We will not get it right now. You will get it there.
Only thing we can make our submission.
Huh?
Your lordship said sorry, my lord. We can make our submission, my lord. That's the main thing.
Yes, we were also because he had got the employment. But anyway, what we had to do, we have done.
Obliged.
Don't worry, it is coming. Already.
Item number 3. Item number 3, I am appearing for the petition, my lord. The minor correction, if you let you kindly take the second page of the judgment, my lord.
Which one? Not yet. Last come at 12 o'clock. Still the file is not come. Might as well. Then where is it? Who brought it? Ask him to find out who is getting the file. Ask him to find out. You have a copy of the order which needs to be corrected.
My lord.
Which page?
Page 2, my lord. Page 2 and the last page, my lord. In page 2, my lord, the
11/1/2008.
Yes, it will be 11/1/2008 instead of 31st.
And last page?
Last page is, my lord, it is OA, WPST 812 of 2023, my lord. It will be, my lord, 160 of 2025.
It's better if we stay.
Item number 4.
May please your lordship. My lord, OA application was filed in 2013 before the before the learned tribunal. Thereafter, my lord,
2013.
13. Thereafter, it was pending. My lord, in 2017, there was an order that in view of the tribunal is not functioning to its full strength, and from tomorrow it will be left without only 2 members to man the 3 benches. It will not possible to accommodate the matter to an early date. So there was no quorum. Since then, my lord, matter was pending, and now the tribunal has become manless. That's why. And my lord, I am going to retire in July. My lord, a police constable was, my lord, implicated in a criminal case, and charge sheet was filed, and he was, my lord,
Yes.
ultimately, my lord, this order was passed at page 60.
Yes. Page 60.
Page 60. Running page. Superintendent of Police, Murshidabad, my lord, against the, may I place the order, my lord? This is in the original application annexure, page 60. While attached, my story has been given, then, my lord.
So two consecutive, two increments.
Yes, yes.
Forfeited.
Yes, yes. Against that, my lord, we preferred an appeal.
With cumulative effect.
Yes.
And suspension period 7 months salary has been deprived. Only
Yes.
suspension,
Yes.
subsistence allowance.
Yes. So
Then-
against that, my lord, we preferred an appeal.
Appeal. Yes.
From page 61 onwards.
Yes.
My lord, it is 11 pages, my lord.
Then what happened in the appeal?
Then the learned, my lord, Deputy Inspector General confirmed the order.
Yes.
Against that, my lord, we preferred the original application. Kindly look at 74. The order is from, my lord, from page 72 onwards. That story has been given. Then, my lord, relevant, my lord, page 73, bottom. Remand such and such, suspension such and such, annual. Column 3, annual increment for 2 consecutive years are forfeited with future effect. The charged officer received the copy of the final order on February 8, 2020. As he was not satisfied with the final order, he submitted an appeal petition against the final order of proceeding to the Deputy Inspector General of Police, Murshidabad Range. Those Superintendent of Police, South 24 Ganas, such and such, which was duly received at this stage. I have gone through the charges, statement of allegations, statement of PWs and also DWs, documents exhibited and proceedings written in defense of the appellant, and finding of EO and final order dated. I have also perused the appeal petition of the appellant and comments of Superintendent of Police, Murshidabad. I have also carefully scrutinized the appeal petition filed by the charged constable against the
final order passed by the Superintendent of Police, Murshidabad. I am of the opinion that the appellant could not put any cogent point in his petition to rebut the charge which were pressed against him. His appeal petition does not deserve any sympathetic consideration. After applying my mind carefully, I am of the opinion charge in this proceeding have been proved. I have further examined the quantum of punishment inflicted upon the charged officer in his proceeding. With utmost care and caution, Superintendent Police Murshidabad has applied his judicious mind in passing the order. Hence, I am confirmed the order. So that was challenged. But my lord, this order is prima facie wrong.
पुलिस वाला कल दिए थे हाँ
of PRB.
PRB route
What are going to do?
regulation of Bengal. not
Well,
Calcutta.
ultimately, in the criminal case, no. My lord, the criminal case has been decided. All the accused persons, including me, দিচ্ছি আপনাকে একটা my lord, acquitted. একটু আমি তো আপনাকে দিয়ে দিচ্ছি একটা কপি কম আছে
It is not reflected from the petition.
No, because at that time case was pending in the petition. I have stated in the petition. I have stated in the present petition. তখন তো পেন্ডিং ছিল.
So what is the relief you claimed in the way?
In the we prayed. One second, my lord. The Honorable Tribunal may be pleased to pass an order directing the authority to not to give any effect or further effect to the impugned order passed by the Superintendent of Police of page 39.
Not to give effect.
Yes. And my lord, no, and further order directing the authorities to revoke, cancel, withdraw the same, give the appellant the usual benefits of continuous service and also incremental benefits.
Why?
Because, my lord, the order passed by the appellate authority was without any reason. He just simply accepted the findings of the Superintendent of Police. I have produced such and such document. I have.
But you have not challenged the.
That was challenged.
Not to give effect to. You are not seeking quashing of the order. You are
Yes.
asking that they should be directed not to give effect to. What kind of prayer you have made? How they cannot give effect to an order which is in subsistence? Unless you challenge the order, this can be a consequential.
To revoke, cancel, and or withdraw the same, and thereby give the appellant.
We will direct them to revoke, cancel, and withdraw, or we will set it as, or the tribunal will quash it. Does the tribunal direct the authority that you withdraw your order?
The tribunal, my lord.
Show any order of this kind.
No. I have followed your lordship.
What kind of prayer you are making?
That should be quashed.
You have to seek a relief that it is to be declared illegal, quashed, set aside. You direct them to withdraw,
Cancel.
revoke.
I have
not to
prayed, my lord,
proceed on
cancel and or withdraw this thereby usual benefits. Cancel.
unusual prayer for usual benefits. Yes.
Cancellation I have asked for, my lord. Your lordship.
No, you have not. You have said that the respondent should cancel it.
Further directing the respondent to revoke, cancel, and or withdraw the same.
Very good.
My lord, your lordship can mold the, my lord.
Yes, we can do everything. You just have to stand here.
Director, the interim order. Now, my lord, he has been in the trial, my lord, he has been acquitted.
Where is that fact in the way?
At that time, criminal case was pending.
So therefore, that is not part of the relief.
That is not there to at that material
Then
point.
you approach the authority with the. Then what is to be done?
In this application, we have stated.
You cannot. Directly, you cannot.
Yes, because subsequent.
You have to approach them with the order. If you want to show any infirmity in the finding of the superintendent of police, we are open to listening. If you want benefit of the acquittal, then you have to bring it to the notice of the authorities and then they will take a decision. We cannot take a decision in their place. Because the police regulation contemplates that they can proceed afresh also. They are not bound by the finding. So they will have to take a decision. Relying on the law which you will place, of course, you will rely on GM Tank, you will rely on M. Paul Anthony, and all these judgments say that same set of
Then, my
evidence,
lord,
same
your
charges.
lordship, my lord, this is my prayer, my lord. In view of the subsequent, my lord, development and acquittal, I shall make a fresh representation. The authority may.
That you can do. Yes.
Yes, because it is pending for 30. I am going to retire in July.
Then you have to go to the appellate authority. If we are not mistaken, there is some provision that this has to be brought to the notice of the appellate authority. Yes. Is there any such provision? We were seeing in some case,
I don't recall that.
2-3 days back in some case we were seeing.
He should approach the authority who has issued the charge sheet, I believe.
How can he, now it is affirmed by the appellate authority, how can he approach? Correct. He may, yes. Yes.
My lord is absolutely right. No judgment ছিল একটা তখন। Faintly I recall now. After
Because
it has come.
my lord,
We have seen it just once, therefore we were not very confident. You
My lord,
must have seen this rule 100 times.
what happened, my lord, the story is that in the Baharampur court area,
How
the-
is that relevant, sir? We
Yes.
have seen there is somebody who is beating up somebody. You are on duty there. You have not stopped them. Rather, they say you have facilitated his fleeing away.
yes.
Also beaten.
No,
And
no,
you have also, yes,
Because
you
in-
have also assaulted.
because there were two, my lord, hitches between the two opposite,
Maybe that-
Baharampur and Jolongi. I was
Therefore, we
deputed.
asked you, you have two options, either to assail the finding here or to bring it to the notice. If you want to bring it to the notice.
Yes, appellate. We can, in view of acquittal, I will get the
The will file.
You may not file also.
We don't,
Within a week, I shall file.
we don't.
Baharampur, my lord, it is.
Very light punishment has been given.
We have seen that, but it is in police. But now you are about to retire. It will not make much of a difference. Pension benefit will. Pension benefit.
Because at the material point time, Baharampur was a very troubled area. He was from Jalongi to Baharampur and Baharampur.
You are being prompted something.
In 2013, 2007-8,
Prompting something. What is it?
My lord, I have not heard him.
All right.
He is not before me.
All right.
wait,
I have seen a very senior judge, তপন বোধহয় ছিলি, Justice Bimal Chandra Bosha.
ও বাবা কথা বললে বলতো।
I have learned from him.
Yes.
We were very afraid to appear.
Before him.
Yes, because we
But I
are
was not.
big. No.
I tell you, Lordship.
We are just
Lawyer,
State government lawyers were afraid, but I don't know about petition.
no, we are just beginner at that time.
I tell you, Lordship. It was a rainy day, very torrential.
Was excited.
Lawyer came without the band and appeared. Thrice, 4 times, 5 times. Then ultimately Justice Bosak said, I don't see you. Again he was saying, you are not before me.
So recently we were unable to hear someone, but for a different reason. Although I violate that rule because of the toothache, I keep a cloth on my teeth, but
That has to be uprooted. Unnecessary. I am telling you, Lordship,
we'll see.
I am 76 years.
We'll see.
Clove is very good medicine.
Medicine for pain. Ultimately, it is to be uprooted.
Very
I'm grateful, man.
Deeply obliged.
Item number 5.
Maybe your lordship. Like yesterday, my lord, my learned friend submitted before your lordship one judgment, Supreme Court judgment, my lord, reported in 1997, volume 9, Supreme Court cases, page 736. But my submission before your lordship, this judgment is not applicable in my case. Why, my lord? Your lordship asked me why. My lord, this case is, my lord, incidental. The incidental observation is different. But my case is separate. There in Supreme Court, special leave application was dismissed. Thereafter, repeated review application was filed one advocate. Without consent of that advocate, another advocate filed an application for clarification of some observation made by the Supreme Court. That is why Supreme Court said, come to a conclusion that no, that advocate is now in existence and the proceeding is going on. So you cannot appear and file the separate application for clarification. That is why, my lord, this proposition is let down in this case. But my case is, and I am paying, my lord, 5 minutes time. 5 minutes. My lord,
15 minutes yesterday, 5 minutes today. So you have 20 minutes.
my lord, as your lordship desire, I am trying my best for my client. Not that I am wasting the court's time.
So don't say 5 minutes, say 20 minutes.
20
Because
minutes.
if you take 5 today, it will become 20. It will not remain 5. It will
Very well,
become-
my lord, as your lordship desire.
Yes.
I am trying my best.
Yes.
My lord, that is the, my lord, incidental observation. But my case is that while the order 4111 application was dismissed, that time the advocate, learned advocate who appeared and argued before your lordship, that time I was not there. But after disposal of that same, but the Okalatnama which was given by the client, the petitioner, but after disposal of that, but the Okalatnama is ceased. I have come before your lordship, fresh Okalatnama. And my lord, the school represented by the earlier head teacher. Now the review application filed the new incumbent, new head teacher. After going to the judgment, he came to me and I have taken the Okalatnama and filed the case. Mala, it is a factual matrix obiter. Here, Mala, kindly reminded, Mala, factual matrix obiter. That is
applicable in my case. And my lord, the successive application which was filed the advocate before the Supreme Court, that is another affair. I am not come here. The one order 41 matter is going on. I hurriedly come and I argued it. This is not. It is the review application. After disposal of that, in my lord, I have gone through the yesterday night, my lord, under the Code of Civil Procedure, Advocate Act, and Bar Council of India's rules. There is no whisper. The review application, that particular advocate can file the review application.
No, there is a whisper. Why not? Why whisper? Loud and clearly it is stated, Lordship. Order rule.
আমাকে শেষ করতে তুমি বলবে আমার সেটা শেষ হোক and my lord, one Tagore lecture, my lord, Justice Mulla come to a conclusion. Well, I am giving this, my lord. What is review? Huh? No, page number কত বলো? Well, I have tried my best. Don't, my lord, I am not, don't be amiss, my lord. I am trying my best. I may be wrong. I may be wrong. Your lordship kindly consider.
We may be patient, but the clock keeps moving.
My lord, this is the usual.
Yes, so 5 minutes will be over very soon.
My lord, your lordship knows, my lord, as and
Yes.
when, my lord, Justice Prabir Kumar Samanta, my senior, while in the bar,
Yes.
one matter he has taken 1 minute time before Justice Torun Chatterjee.
Yes.
But the matter was going on 1 hour. Then Justice Chatterjee asked Mr. Samanta, yes, what is going on? 1 minute, it has come to 1 hour. Judgment reserved, and that case I allowed, this application was allowed. So your lordship, give me chance. I am referring this only because, my lord, here, review of judgment, I am reading thought. A party aggrieved by degree or order may apply for review of judgment, not only where no appeal is allowed from it, but also where an appeal is allowed from it, provided that no appeal has been preferred by him. The fact that some other party to the degree has preferred an appeal is no bar to an application for review of judgment unless the ground of such appeal is common to the applicant and appellant. My lord, Order 41, Order 47, Rule 1 says, an application for review of judgment may be made on any of the following grounds. My lord, ground number 1, discovery by the applicant of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge or could not be produced by him at the time when the degree or order was passed. 2, on account of some mistake or error apparent on the face of record. Here my case, ground number 2, because the trial court, don't be amiss, my lord, I am not repeating, only, my lord, reminding your lordship, the suit court come to a conclusion, the suit is not maintainable on the defect of party, because the degree cannot be executable, because the degree against the primary teacher, but he is not the custody of the property. It is the school authority property. It is governed by the state of West Bengal. It is the government property. Next, for any other sufficient reason, this is, my lord, that is not applicable here. And my lord, last paragraph, my lord, I am saying before your lordship, where there is not sufficient ground for review, the application should be rejected. And my lord, the law does not allow. My lord, the law does not allow. A second review is not applicable. But in the Supreme Court, they have repeatedly filing the review petition. That is why the proposition of law made by the Honorable Supreme Court. This is my only submission. And another one point, my lord, that is very vital, while I have filed the review application, some mistake and or error on the face of record, it should be corrected by the Honorable High Court at the hearing of the review application. That's all, my lord.
Lordship, on this point, on this judgment, Lordship, here, Lordship, I specifically relied on this portion, Lordship, at paragraph 1, where Lordship, in review petition number 2670 of 1996, where the 3 judges bench held otherwise, Lordship. In that case, Lordship, the SLP was dismissed and Lordship, a review petition was filed, but the learned advocate who filed the review petition was nowhere related in the while the hearing of the SLP was going on. So that practice the Supreme Court has deprecated. I am relying on that portion which is mentioned, that unreported judgment which is mentioned in this case, Lordship. Secondly, Lordship, in Lordship will kindly come to order
Referring to paragraph 1.
Yes. Lordship kindly sees that judgment 1997, volume 9, SCC 736 at page 737. In the middle, Lordship, a portion of a judgment is quoted there. An unreported judgment. That portion only I am relying upon. May I read it out for your Lordships? In review petition number such and such, in CA number such and such, a bench of 3 judges, to which one of us was a member, had held as under. The record of the appeal indicates that C such and such was the advocate on record when the appeal was heard and decided on merit. The review petition has been filed by such and such, who was neither an arguing counsel when the appeal was heard, nor was he present at the time of arguments. It is unknown on what basis he had written the grounds of review petition, as if it is a rehearing of the appeal against our order. He did not confine to the scope of review. It would not be into the interest of the profession to permit such practice. That apart, he had not obtained no objection certificate from the advocate on record in the appeal, in spite of the fact that the registry had informed him of the requirement for doing so. Filing of no objection certificate would be on the basis for him to come on record. Otherwise, the advocate on record is answerable to the court. The failure to obtain no objection certificate from the erstwhile counsel has disentitled him to file the review petition. Even otherwise, the review petition has no merit. It is an attempt to re-argue the matter on merits, which is exactly what is happening here, Lordship. Moreover, Lordship, if Lordship kindly comes to the Code of Civil Procedure, Lordship.
Yes.
Order 3, Rule 4, Lordship.
Yes.
This is regarding appointment of pleader, Lordship. I am placing Rule 4.
We have it. Thank you. Explanation A.
Yes, Lordship.
You're relying on explanation A.
Explanation A, Lordship. Yes.
Yes, we have seen that.
First, Lordship, Order 3, Rule 4.2. Every such appointment shall be filed in court and shall for the purposes of Sub-Rule 1 be deemed to be in force until determined with the leave of the court by a writing signed by the client or the pleader, as the case may be, and be filed in court, or until the client or pleader dies, or until all proceeding in the suit are ended so far as regards to the client. Explanation for the purpose of this sub-rule.
So proceeding is defined and explanation A covers your case.
Yes, Lordship. So here in this case, a no objection certificate was required. Now, regarding the other point, Lordship, regarding the scope of the review application, Lordship, now it is settled that, Lordship, on the garb of review, a petitioner cannot, Lordship, re-argue his case. Now, his case is that the suit court, Lordship, dismissed the suit for non-joinder of necessary party. But thereafter, Lordship, appeal was preferred. A second appeal was preferred. Now, the second appeal did not find any substantial question of law and did not admit his second appeal. So, Lordship, this point, Lordship, cannot be taken in a review application since it does not satisfy any of the grounds mentioned in Order 47, Rule 1. He cannot reopen his issue here. If he is indeed aggrieved, he has other remedies. He can go there and challenge it there, but not in a review, Lordship. In this regard, Lordship, I shall be citing only one judgment, Lordship, that is reported in 2022, volume 17, Supreme Court cases, page 255. I am relying paragraph 27, 29, 33. এটাই দিয়ে দেবো আপনারা। 27, 29, 33. Lordship will first kindly come to paragraph 27. It starts from page 271. At 272, Lordship will kindly see. Lordship, in the middle. Lordship, another judgment is quoted, Lordship. This Shivdev Singh versus the state of Punjab.
1909. 63 Supreme Court 1909.
Lordship, at page 272.
272.
Yes, Lordship.
Shivdev Singh.
The fourth line from the top.
Yes, 63 Supreme Court 1909. That is
Lordship.
some things I remember.
Yes. So, Lordship, here also it was stated, Lordship, that when the power of review may be exercised on discovery of a new and important fact or evidence, which after the exercise of due diligence was not within the knowledge of the person seeking review or could not be produced at the time when the order was made. It may be exercised where some mistake or error apparent on the face of the record is found. It may also be exercised on any other analogous ground, but it may not be exercised on the ground that the decision was erroneous on merit, what he is now arguing, Lordship. That would be the province of a court of appeal. The power of review is not to be confused with appellate powers, which may enable an appellate court to correct all manners of error committed by the subordinate court.
Shivdev Singh was on a different, actually there was one person was not impleaded in 226 petition. Then he approached the court. The Supreme Court held that he could file a review, although he was not a party, because his non-gender would enable him to file a review. That was Shivdev Singh.
He the affected party.
63 Supreme Court 1909.
And Lordship, thereafter, everything, Lordship, which has been stated regarding the scope of review, only Lordship will kindly come to paragraph 33. The same thing has been, Lordship, repeated. So, Lordship, my respectful submission is that first, the review application, Lordship, is not in form. And secondly, Lordship, the grounds, Lordship, which has been agitated in the review application does not come within the scope of
review is not to be confused with appeal. Is recently to 2024 to SCC page 362.
Lordship.
The same thing.
Yes,
Yes.
that is all, Lordship.
Yes. Very well. Heard the parties.
After completion of that argument,
It's the date after 15 days.
15.
my only submission, kindly, your lordship, a humble prayer, kindly go through my written notes of argument. Because I have given the one line that the learned advocate Jivan Hari Mullik, who was at the time of hearing this appeal, he was in London. He has come just this month. So this is the fact. I have taken this point.
But this was not argued.
Then you would have said that we have not obtained an NOC because of these circumstances.
No, that
Said in a petition.
argument is NOC is not required.
Yes. So therefore, your argument is not required.
Yes.
Not that it was not possible. Yes.
And not required.
Not
I-
possible unless you say in the petition, you cannot say. You are not said in the petition. Yes.
Very well. Get floor. CAB for orders.
For orders.
Yes, it will be passed.
Grateful.
Item number 6.
বলে গেল না তো তুলসীরা অ্যাপিয়ার করছিল বলছে অ্যাপিয়ার করছে না
না,
কে অ্যাপিয়ার করবে
ফ্রেশ সার্ভিস করতে হবে।
জজ সাহেবকে বললাম আমি করে সার্ভিস করে দিই
Oh, this is that case where a copy was required to be given.
Madam, kindly give me liberty. I will serve the copy. Let it come on next Tuesday, madam. I
In
will
view
serve the
of,
copy
in
the
view
meantime.
of again, they will say it has been served 2 days back, 2 weeks.
I'm grateful.
Yes,
At least 48 hours
for
for this processing this.
your movement of file is computerized with the authorities.
It's all. The computer system is got fucked up.
Yes, yes, we had that there, WPID, DMS, we called it in Bihar. All the district magistrates, all secretaries, Advocate General's office was connected. So the,
actual did the service by email copy of the.
Yes, yes.
Respondent office.
but still they insisted on coming physically.
Item number 7.
Chip item number 7, this is that matter where the state was of the making the submission that PSC was the recommending authority, and upon direction from the PSC, we have appointed the private respondent. Lordship, in the last occasion, Lordship was pleased to direct us.
My lord, in this matter, my lord, Mr. Sukanta Chakraborty is appearing for Public Service Commission. My lord, he is ill, my lord, he has not come to put, my lord, today.
We have recorded that mere consultation process is there. Actually, it is the state who will appoint.
Absolutely not. Even the order,
What is the issue?
issue is
The-
not the petitioner before the respondent here.
Yes.
Challenge an order of the authorities wherein the private respondent in the original application was given the promotion to the post of CPO, Chief Probation Cum Aftercare Officer. On the pretext,
Probation, no?
Aftercare Officer.
Aftercare officer.
So probationary officer in the jail.
Absolutely.
Yes,
correction
yes,
committee, my lord.
yes.
Now, my lord, what has happened, my lord? I was not given the promotion, although undisputed fact remains I am the senior most deputy superintendent, deputy CPO, and the person who was given, he was below me. But still, they have given the promotion to that person on the pretext, my lord, they have said that one proceeding was initiated after the promotion order was there. The promotion was given on 19th of March. And my lord,
As on the date the promotion was given to your junior, there was no proceeding.
no proceeding, my lord. It was in the month of April that was initiated, or in
Month of
March, my lord, promotion was given. March
Charge sheet
19th.
was not,
And
charge
my
sheet
lord,
was filed thereafter.
and
Charge
charge
sheet
sheet
was
was-
filed. We gave 2 recommendations, Lordship, respondent and private respondent.
now we are reminding.
Yes, we gave 2 recommendations to the PSC.
What the tribunal has done, it has allowed the claim.
Yes.
So therefore, what is wrong with the tribunal's order, please?
Lordship, the only difficulty is that we have shown one page wherein it specifies that we have given recommendation to the PSC and have asked that you choose whoever you recommend, we will appoint that person. The thing is very simple.
In that, his name is figuring.
Yes, we have recommended. We have recommended. Just a second. Not petition টা কোথায় গেল রে? If Lordship kindly comes to, pardon me, Lordship. This page number 52. 52, Lordship. It starts from page number 50, rather page number 49, but Lordship will find the name of the petitioner as well as the private respondent in page number 52. These are the names of the two candidates we have recommended.
He is at serial number 2.
He is at serial number 1. Now, admittedly, the show cause notice was issued prior to this. We couldn't have. The only difficult, we can't hide what was initiated. We just said that this was the thing, and the PSC was the authority who has taken the decision, and they have communicated to us. Now, in the last occasion, Lordship, we have tried to show that in regard to the in accordance to the constitution.
This is a seniority list. This is not a recommendation.
This is Lordship, yes, I'll just show Lordship. Kindly comes to page number 49. Page number 49.
So it is part of this.
Yes. Because the annexure starts from page 50.
Where is the promotion order?
Lordship kindly comes to page 61 once. So this is the letter from the commission which we have received, where in the fourth line from last, the commission did not find Officer Meen Mohammad Yasin suitable for this promotion. And then come the appointment that is at page 70, Lordship. Now here, Lordship, last paragraph, if Lordship kindly sees, the appointment is made on recommendation of PSC, Public Service Commission, West Bengal.
Where are the, where is in the OA?
In the AO.
Page.
Yes, yes. Page 40, page 22. তাই তো prayers আপনাদের prayers হ্যাঁ page 22 8 clause 8 relief sought for.
So part of it has been partly allowed.
No, it will be allowed.
The
His promotion has been quashed.
yes,
So he has not assailed the order.
No, my lord, he does not ascend the order, my lord, although he was party before the.
yes, he has not challenged it, and the disciplinary proceedings which was pending, he has not challenged that also.
No, no.
না যে promotion দেওয়া হয়েছে.
Yes.
The person who got the promotion my lord, was the private respondent before the learned tribunal, but he has not.
It has been quashed and he has not challenged.
No, he enjoyed that thing and till the my lord, initially writ petition was moved, it was dismissed for default. At least thrice they didn't appear. My lord, your lordship knows, my lord, Justice Harish and my lord, Justice Praseed Biswas was there. His lordship was very reluctant to dismiss any application. Ultimately, his lordship dismissed the application. They took nothing. Thereafter, an application was filed for restoration, ultimately came before lordship. And that person in the time has retired, another person has become the CPO.
Yes,
And he enjoyed everything, the fruits of the orders, of the promotion post, but not the orders.
So his pensionary benefits must have been.
Well, he is getting the pension of the private respondent therein. He is getting the pension as there is no order.
there is no order. There is no.
The tribunal's order is practically still taken into toll by the authority concerned and the person who got the benefit.
So he continues to draw the benefit of that post.
That is that they have done well.
As on date, the petitioner, the respondent has also retired, lordship.
So did you send again? Did you send the recommendation in his favor to the commission?
We have given his name as well as the person who was
In
selected.
compliance of the tribunal's order, did you send the recommendation?
Not, no.
Why? If your plea is that it is for the commission to do, then unless you send it, how the commission will do? You have just shown us the exercise.
Yes,
You send the
lordship.
name of the person the commission examined, recommended, you appointed.
Yes.
So did you take the step that you were required to take?
Lordship, we immediately filed the appeal, but we have not honestly sent any recommendation. We have not forwarded because commission was a party to the OA proceedings as well as here
You have
also.
done your part, they don't do it. They know how to get the order enforced.
We have,
If we are asking you, then what is the informality in the order? You are required to initiate. If you don't initiate, how it can be done? Commission will not start on its own. The process of consultation is initiated at your end.
yes,
Then you
lordship.
send it for consultation, then only things will move. So therefore, there is no saying that it is not for you to do. If that is the only ground, then
Lordship, the only difficulty I'll say, what has happened, because the post, we cannot create another post because someone is already there. Now he is already retired. What he can get,
not going to occupy the post.
he'll be getting the retirement benefits.
Background
Lordship,
is also nothing. You don't have to dislodge anyone to give him the benefit.
yes, Lordship, I
So neither
don't.
that obstacle is staring at your face, nor there is a problem with initiating. You can't say that initiation has to be done by the commission. Once you move the file, and the logical consequence will follow.
Lordship, I go down because last occasion also Lordship was pleased to ask us the same question only.
So if you have no answer, then
But the
we'll record
difficulty is that,
submission.
but the difficulty is that since Lordship PSC was a party there also, and we have recommended. It's not that we have not sent it to the.
We are not on history. We are on, either you tell us what is wrong with the order, don't tell us your difficulty, because if you find you have done nothing after the order. Therefore, the difficulty would be maybe if they proceed for contempt after you have initiated, nothing is happening, then you may say that what can we do? It is lying with the commission. As of today, what is that? That plea means nothing. We don't know what your case is. That's what we are asking. What's wrong with the order?
Lordship, we cannot create a post. He'll be getting his benefits now, as because
long
at that time when the matter was filed, the difficulty was that we could not have created another post. At that
When
time,
did
he was working.
retire? When
He has retired in 2024, and the matter was filed in 2022, Lordship.
The order is of
Order is of 2020,
Of March 2022.
2022. 2022, yes. That time he was working.
what is the infirmity in the order? Tell us if you want to make any submission.
Lordship, at that time the infirmity was at that time, but because now he's not working. At that time, the direction was upon us to give him to promote him and make him work as what he has prayed. But now that difficulty is not there because he has retired and he'll get the retirement benefits. Lordship, I'm not on that now. Lordship, that part has already been dealt.
What are
It
you
has
on? We
become.
are asking you. We are waiting for you to make any submission as to the order. What is wrong? Why we should interfere with?
Lordship, as on date, whatever falls from Lordship.
Yes,
Lordship,
take down her learned advocate for the
only
state.
one it should not be a hindrance in regard to the
That's
step.
not even an issue in the OA. Why do you want to touch that issue? Yes, heard the learned advocate. It's not your writ petition, it is their writ petition.
I couldn't even move, my lord. I got an order. How could I move a writ petition even?
Huh?
I couldn't even move, my lord. I got a favorable order from the tribunal. So I couldn't even move.
No, but you don't know whether you ever moved for contempt.
Yes, sir. Contempt is pending in the contempt, my lord. What my learned now matter is over. They said we are taking steps. We have approached the finance. Now we will comply with the order, but
Everything is in deposit for you.
Item number 8.
My lord, I am for the petitioner, my lord, only not today, my lord.
Why, madam?
It's going, matter is going on, my lord, code number 30.
13.
Yes, sir. petition মামলা চলছে।
Very well, not today.
Date,
Not today, madam.
date for
That's it. He is in full vision.
Item number 9.
So, Lordship.
Last occasion, there was the direction upon the petitioner to file a reply, your lordship. I tender apology, your lordship, and sought for some 1 week extension to file the.
You are for the writ petitioner.
Here it is for the petitioner, your lordship. Actually, even
You are also appearing.
next matter. There's only 1 week time.
As paid by petitioners council.
Get foolish.
Item number 10.
Oh, yes, you wanted to file something.
Certain correspondences between office liquidator and judicial department have been annexed in the affidavit. Now, I do not find anything that cabinet approval was there.
Lord, I like to place my, yeah, I'll make my submission. If he wants to, let him make his submission.
So there is no issue of reply or anything.
No, only correspondence. But if your lordship kindly sees that this matter pertains to reversion and recovery. Now, the entire reliance has been placed by the respondents to page number.
Just reversion from which post to which post?
Estate superintendent, estate supervisor to lower division assistant, LDA. Now, the regular promotion was given
and he became estate supervisor when?
Yes, but kindly see, just a minute, Lord. One. If your lordship sees the.
And he was reverted on which day?
But page 33 will reveals everything. Page 33.
Give the date.
Yes.
Reversion on which date?
Yes. But 1st September 2014.
No, that is the day he became estate supervisor.
Right. And reversion took place on 1st September 2015.
Oh, so 1 year.
1 year, just 1 year.
So this reversion also had the consequence of recovery.
Recovery.
This is an order of 1915.
1915.
At which page?
Page 33. Serial number 5 is the petitioner before your lordship.
No, this is a quantification of the overdrawn salary. Where is the reversion order? This is as a consequence of the reversion.
But in this order, if your lordship sees serial number 5 and last but one paragraph, then it is clear.
Last but one paragraph.
Yes. It is noted that with the shifting of promotion date, the designation of
All these persons.
Yes. Now, third line, Sri Orgho Mojumdar, the petitioner before, from supervisor of estate to UD assistant with effect from 1st September 2015. It is further noted that the designation of so and so is not required. Now, so the Orgho Mojumdar, the petitioner, was given the post of UD assistant with effect from 1st September 2015. And the order is, your lordship, the order is at page 31. If your lordship sees page 31. This is only in respect of the petitioner.
No, this is not a reversion order.
No. Page 33, order was passed on 19 May 2022.
Correct. And this is relying upon some order. Which order? The amount of overdrawn salary ascertained for the employees for their wrong promotion in consequence of wrong implementation of additional HA post, creating order, so and so. Is as follows. So have you deposited or you have not deposited?
Yes, sir.
Have you deposited the amount or no?
No, they have deducted from my salary month to month basis, and they have fully realized. When the matter was pending before the tribunal, they started deducting.
Tribunal, you prayed for any interim relief?
That was not granted. Interim order was prayed for, that was not granted. And ultimately, the petitioner lost the case also. Therefore, I am before your lordship. Now, kindly see another 2 pages I shall show to your lordship, page 39 and 40. If the reversion takes effect, then I shall be losing, how much I shall be losing in my monthly salary. Kindly see about more than 10,000.
But that is not the issue. The issue is whether reversion is justified or not.
Yes.
So
Now, only one reliance has been pressed by all the respondents, page 67. That is the reason for reversion and recovery. Page 67, that is the finance department's memo issued on 6th August 2021, long after the promotion was given effect.
That is not, sir. They are saying it is because the promotion was in wrong implementation of an order of 9/1/12 of the Judicial Department. Based on Finance Department observation dated 22/12/11. What they are saying is that there is a wrong implementation of the Judicial Department's order of 9 January 2012, which has been found out by the Finance Department in December. It is in reverse order. We don't know
Yeah,
what they are
that's
saying.
there. But page 64 is there.
64.
Page 64.
21/12/11. Yes, this is
9th January 2012.
yes.
But this restructuring of the cadre was on the basis of page 67.
No, 67 is much later. How can it be on the basis of 67?
Because they have placed reliance on this
But
and
67 is much later. 67 is of 21.
right.
This is of 2012.
12.
It cannot be on the basis of 67.
What they have said, Lord, may I just clarify, Lord, what they have said in their affidavit, that due to wrong implementation of this order, promotion was given.
How can it be 21 order? How it?
No. This page 64, 12th order. 12th order implementation was erroneous according to them. Why erroneous? Because of page 67.
Because of page 65, not 67. 67 is of 21, sir. How can it be because of 67? 65 is the Finance Department says that posting on supervisor is being done from lower division clerk.
Yes.
Therefore, it need not be included in the promotional post, whereas they have included in the promotional post. This is the thing.
Since page 64 and 65, 64 and 65.
65 and 64. First 65, then 64. 64, they are saying, is in wrong implementation of 65. Therefore, a promotion has been granted which was not due. Now they have rectified in 21. They say, give the money back. That is the only thing.
No, in 21, Lord.
When they have rectified?
In 21, your Lordship sees not because I got the benefit.
When they have rectified?
In 22.
In 22.
Yes.
And how long you served after the promotion?
I am still serving.
You are still in service. So what is the amount of recovery?
Amount of recovery is about 70,000.
Only for 1 year?
Only for 1 year. 67,000 and odd. 67,000 and odd.
67,150.
Why only 1 year recovery?
Shifting of the promotional post.
Oh, from then he became entitled.
Yes.
After 1 year, he became entitled. Oh.
Automatically, he is now serving in the promoted post. 19/20/14 to 19/20. It shifted the date. This is in terms of the government's policy of 2008. But the implementation had to be done later in view of that order.
So he got it due on the due date. What is the due date on which he got?
2015.
Where is that order? Of his promotion, due promotion? Oh, that says, that is in the, already in 33 it says
yes,
that the date has shifted.
He's not the only one. There are as many as 6 employees. All over.
One has approached, no, other has.
So then what is wrong? Tell us. They say that there is a finance department decision that LDC are being appointed as supervisor, therefore they need not be included in the promotion post.
Right.
Ignoring that, the appointing authority makes it a promotional post, giving it a higher scale. That scale was available to you 1 year thereafter by virtue of your due promotion.
Right.
That 1 year they say it has been paid in excess. This is the case. So therefore, what is your submission? Why it should not be done?
My submission would be this, Lord. I was, if your lordship sees page 31 once again, page 31, I was given the promotion to the post of estate supervisor, Lord, without any misrepresentation, without anything. I served in the post for 1 year. Lord, there cannot be any recovery because there is no misrepresentation. And on their own volition, they have promoted me. Lord, I served the post to the satisfaction of all concerned. Now, Lord, suddenly, Lord, after long 8 years, Lord, they sought for reversion and recovery. Why?
Long 8 years, but recovery only of 1 year.
No,
That is why we asked how many.
After 1 year, I became entitled.
So Rafiq Masih, even if you rely on Rafiq Masih, then
yes, Rafiq Masih is there.
How it will apply? It says that maybe you are LDC, so therefore that way you are covered. But the benefit did not flow to you for a long period. It was only for 1 year. There the consideration is if the benefit has flown for a long period, maybe 5 years or more, then. So that will not apply. Therefore, we are asking you, what is the submission? Why they should not, why they should pay this due benefit which is not due to you? You did not challenge the correct implementation of your promotion or shifting of your promotion. That you have taken.
No. I got a promotion. I served to the satisfaction of all concerned.
In 15, you got the promotion by virtue of the due date.
Right.
That you have not challenged.
No, certainly.
Therefore, it is only the recovery which is an issue.
And reversion is also an issue, Lord. Reversion is also an issue because, Lord, what they have done.
There is your prayer in the OA.
Yes. Your Lordship, kindly come to page.
Nothing about reversion. Come
Yes,
to page 26.
Yes, I shall show to your Lord.
Come to page 26.
Lord, first prayer, order to issue directing the concerned respondent not to deduct the alleged overdrawn amount.
Correct.
Number 2, an order to issue thereby directing the respondent to refund back the amount already deducted from the salary.
No issue of reversion.
No, then we'll kindly see. An order to issue thereby holding the order of promotion in favor of your applicant to the post of
Not to be an onus one.
from lower division assistant by office order number so and so. So
why it is not erroneous? Tell us then.
Lord, it is not erroneous because of the reason. I tell your Lordship. Kindly see, Lord, I shall just show your Lordship.
Come to page this 65. What does it say? Your promotion is done by virtue of page 65 and 64.
Yes.
Yes. So let us see what 65 and 64 says.
There were 22 posts of LD clerk, 21 posts of UD clerk, and 2 posts of head clerk in scale number so and so under the office of the official receiver, High Court. So 4 minus 2 additional post of head clerk in scale number 10 may be created with effect from so and so 2008 in terms of finance department memo number so and read with so and so. The post of accountant cum auditor and supervisor of estates are filled by promotion from LD clerk as per practice. These posts are not promotion posts of LD clerk as per prescribed recruitment rules. These posts were also not taken into account at the time of implementation of 1:1 promotion of LD clerk. So those posts cannot be taken into account at the time of creation of 10% head clerk supervisory level post. The staff pattern of the said office as on so and so would be as follows. Now, if your Lordship sees page 64, the undersigned is directed by order of the governor to say that the governor has been pleased to sanction in terms of finance department memo number so and so, read with so and so, dated so and so. in the Office of Official Receiver, High Court, Calcutta, with effect from 1st August 2008. I am also directed to say that the staff pattern of the said office as on so and so would be as follows. The charge in this regard will be debited to the head of accounts 2014 Administration of Justice so and so. Now, my lord, on the basis of these 2 pages, I was given the promotion from lower division assistant to estate supervisor.
That is admitted. That is
Yes,
not in
yes.
dispute.
Now, my lord, what they did, my lord, in terms of page 67, they, my lord, after 7 years or more, slightly more, my lord, they, my lord, held my promotion to be erroneous on the basis of this. Now, my lord, this page 67, what it says, my lord, this is the finance department order. But here your lordship would find may kindly be approved. This is subject to approval by cabinet, of cabinet. Now, my lord, this was never approved by cabinet. So this could not be given effect. And my lord, it has to be prospective, not retrospective. Even if it is approved by the cabinet, it has to be prospective. How can it be? This is not judicial pronouncement. Judicial pronouncement is always retrospective, but administrative order is always prospective.
When an order is corrected and there is a consequence involved, it cannot be done. There are hundreds of cases.
No, but it has to be.
There are hundreds. You can't say it cannot be. If it is not, is a different thing. But it cannot be, you cannot say it. There is no rule.
There has to be specific mentioning that.
Therefore, it is not that it cannot be.
That's correct, Lord. I
It
stand
may
corrected.
not
I
be
stand
in this
corrected.
case. Yes.
I stand corrected.
Don't say it cannot.
No, mistake can always be corrected.
Mistake can be corrected and recovery can also be made. But subject to exceptions which are well now settled. Rafiq Masih relying on Sahib Ram and all these
Yes.
cases where there is no misrepresentation and all these things are there,
Yes.
where the benefit has accrued for a long time. But it's not that it cannot be done. It can be done.
No, but Lord, this order, page 67's orders were subject to.
So this is the basis of the correction.
Yes, this is the basis. They have said in their affidavit. If your lordship sees their affidavit at page, Lord, kindly see page. No, really finish page. Lord, page 48, if your lordship sees the basis. Page 48 of the affidavit filed before the tribunal by the respondent number 3.
No, they are not disputing. They are basing it on this.
Yes,
That's
absolutely.
That's not in this.
Lord, had there been no page 67, there would not have been any correction or rectification or recovery or reversion. And Lord, the page 67 was an order subject to approval by the cabinet. That was never done.
This does not direct for anything to be done for past.
It's fine. We are directed to do it. Those documents, my lord, I wanted to discuss with your lordship found out. And this we have annexed to my affidavit which I have filed today.
So which is the order impugned before the tribunal?
My lord,
Lord, the order of recovery as well as the reversion.
So where are those 2 orders?
So that is the single page order, that is page 30, page 33.
33, that order. But this is not an order. This is a file noting. This is a file noting, office note.
it's an order.
Order.
Because consequential effects of this order.
Who has passed this order?
The finance minister. Up to time the signature is below me. Honorable Finance Minister 3821. He signs it. And the order number is given on the left hand column.
38.
Yes, 3821. and the order date is, my lord, 6/8/21. Lord will find the last, my lord, on the left side. After this signature of Honorable Finance Minister, 3/8/21, my lord.
Page 20, page 33.
No, no, page he's.
No, no, page 33, who has passed the order?
33 is the order.
Yes.
33 is the order.
It's the consequential effect of this order.
Yes, who has passed this order?
But this is the official receiver. This has been passed by the official receiver. He is the implementing agency authority. We have been directed by the judicial department to do this. Those documents I have annexed to my affidavit.
What is the date of this order?
19 May 2022. Page 33, left hand side.
19/5/22.
19 May 2020.
The signature will have seen and then A. Mazumdar will have, and then 19/5/22.
You have, why did you issue this order? Why have you issued this order?
It's my affidavit which I have filed today. Will kindly allow me to place 3 documents.
Today's affidavit, respond number 3.
I only filed one affidavit, one before the tribunal, and this is the affidavit. There was no direction to filing affidavit in opposition, but this is the affidavit subsequently. That affidavit is my affidavit to the tribunal. Your lordship will find at page 44 of the petition.
Yes, what is there in this affidavit?
Yes. Now here, my lord, finally comes to my lord, page 9. Annexure R2. Before that, my lord, kindly come from, sorry, kindly come to page 7 first. R1. This is the letter dated 2nd September 2021. After that order was passed, 6/8/21. But this is a letter issued by the Deputy Secretary Judicial Department to the official receiver.
Sir, we are asking you, where is the direction to make a recovery?
Yes. No,
We are not asking you how they have asked you to give the details of post and all that.
No, no.
Where is the direction
Yes,
to you to make recovery of the benefit paid for the 1 year?
Lordship.
Just show us that order.
Yes. My lord, kindly comes to page 11. This is dated 29/11/21. Judicial Department, my lord, kindly sees, my lord.
Sir, we are not asking you about your staffing pattern.
No.
We are asking you, you said you have issued the direction in compliance of certain direction issued by the judicial department.
Lordship.
Which is the direction asking you to make the recovery?
No, kindly see, my lord. I am directed to request you to furnish a comprehensive report, my lord, obeying the condition. They have directed us to.
Where is that condition we are asking you?
But the condition is 6/8/21.
Huh?
That order, 6/8/21 at page 67. This is on the basis of this only.
So there is no order then, that means.
Yes, and then, my lord, after this, kindly comes to page, my lord, 24. Kindly sees 24.
There is no order directing you to make any recovery. If there is any order, for the last time we are asking you, show which letter says in so many words to make a recovery.
Yes, page 24.
Yes.
After this 24, here they say you obey, and then, my lord, 25/8/22. Kindly sees. With reference to the subject noted, I am directed to request you to furnish the following necessary documents for taking further course of action from this end. Copy of the pages of service books of all concerned staff showing entries of recovery of their overdrawn salary who were wrongly promoted.
Copy of pages of service book of all concerned staff showing entries who were wrongly promoted.
Wrongly promoted. Of the recovery of their overdrawn salary who were wrongly promoted. And then, my lord, received copy of TR form number 7 for refunding such overdrawn salary. So after this, my lord, we are bound to, my lord, withdraw.
Sir, this is a general order.
No, this is, my lord.
This is not with reference to these persons.
Yes, lordship, that will find, my lord. That's the reason I wanted to place the first letter, my lord. These are documents started, my lord, all these correspondences, my lord. started from this document. Immediately after the order was passed, page 7. This order is 6th of August, my lord. After this, 2nd September 21, my lord, they write. I am directed to request you to please furnish information regarding projected staff pattern of your establishment with effect from 1/8/2008. In keeping with the observations of the finance department along with the gradation list of employees on that date and furnish the same. This is in the light of that order. The reference, my lord, will find order so and so. And we are in forwarding a copy of the finance department's order number so and so dated 6/8/21. They enclose that order with this letter. The next page, my lord, page 8. After this letter, my lord, we supply the information, whatever they ask for, my lord, showing staff pattern, everything, what they ask for. After this, my lord, they write us on 11, page 11, my lord, this letter. This is dated 29/11/21. Page 11.
Others who were promoted on this post,
Lordship.
their overdrawn salary has also.
Yes, sir, they themselves voluntarily they have given.
Voluntarily.
Yes.
He is the only one contesting.
Lordship. So after this, my lord, they say 29th of November 21, my lord, kindly see, my lord, I am directed to request you to furnish a comprehensive report obeying the conditions laid down by the finance department regarding the staff pattern.
Which page?
Page 11.
Page 11. 11.
Page 11, my lord. Annexure R3.
This is for you to do.
No, obeying the condition, my lord, they further clarify by their letter, the one I.
1/8/2008, where is this condition?
Lordship.
In 1/8/2008.
No, that is the government's policy. Kindly takes for once, my lord, we have explained that in our affidavit to the tribunal, kindly comes to page 44 of the petition. Kindly takes my affidavit once. We have explained it. Yeah, they say to obey, my lord, and after this they say you deduct. And my lord, this promotion was given on temporary basis.
What is 1:1 policy? I mean,
Lord, kindly takes page 44 of the application, my lord.
44.
Lordship. My affidavit to the tribunal.
Promotion policy.
Promotion.
1:1.
What?
1 LD, 1 UD.
My lord, paragraph from paragraph 3, subparagraph Roman 1 onwards.
Oh, so it means that once it will be done from LDC and once it will be done from.
1:1, yes, yes. Yes.
1 LDC.
And there was by the order of 6/8/21, my lord, one new
This is a policy.
lordship, government's policy.
So there is no distinction between UDA and LDA.
No, if one for every one post of LDA, there has to be one post of UDA. That's the government's policy. But that couldn't given effect to, but since there was no order. And that was clarified by 2021.
That could not be given effect to?
Because there was no such order for implementation of that order. That implementation came in 2021 by 6/8/21.
Be done retrospectively, then there is nothing.
Policy at page 57. 1:1.
And the policy, yes.
Yeah, 47, 57.
Page 57 is the policy, my lord, government's policy. This is 31st May 1985. You're not very legible in my copy, of course. It in fact start from page 52. my lord. Lordship kindly looks from page 52 onwards.
The UD assistant's next promotional post is
But supervisor,
Supervisor or head assistant.
head assistant then.
and LD's is upper division.
LD is a lower division.
From LDA
So LD's promotion post is upper division.
Upper division.
And upper division is supervisor.
Supervisor or head assistant.
Then not this new post created head assistant. There were 4. Another new post is created by the 21
And he was in lower division.
law division. Law division assistant, LDA. And UDA is upper division assistant.
Now, for a 2022 government chief administrative officer, which is called Bodababu superintendent. Now it has been
Head
redesignated.
clerk. Head clerk was section officer.
Section officer, now chief administrative officer. Nomenclature has been changed.
Good. So he was not supposed to be promoted from LD. He was that was a post which he could occupy only if he was upper division.
In 2015. And pursuant to this, my lord,
2015 he became upper division assistant.
no, this was given Millers on 2014, 1st September 2014. But pursuant to the 2021 order, in giving the effect to the policy of the government of 1984, with the policy came into effect from 2008. So the staff pattern changed. Thereby, my lord, this promotion, which was entitled to, that became entitled to from 1/9/2015 instead of 1/9/2014. So there was a shifting of promotion, the date of promotion by 1 year.
But this was decided in much later.
Yes, but this was given with retrospective effect.
Where is that retrospectivity? That is what we are trying to see. It could have been, but does it direct that past whatever has happened in the past is also rectified?
My lord, kindly sees your
Which order says, because this is the only order, 6821,
lordship.
it does not say that whatever has happened in the past, it says post facto. Uses the expression post facto.
My lord,
GO number 15014, 27/9/85, read with 5 FD 6885 will stand ratified on post facto basis.
no, before that, my lord, lordship, yes. Before that, lordship kindly sees, as a result of which the combined strength of LDC and UDC as on 1/8/2008 under the office becomes 48, that is 22 plus 21 plus 5, and 10% of which comes to 4.8, say 5. So we may agree to create, my lord, then says, with effect from 1/8/2008. 1, that is 5 minus 4 is equal to 1. More post of head HC. That should be head clerk, possibly. In pre-revised scale, number 10, under the office of the official receiver, High Court. So when this is effective 2008.
But it does not direct for any recovery.
In terms of, no, because if I am given promotion to somebody, and that promotion order is also temporary. Page 33, you will find the promotional order is on temporary basis. Page 33. I'm sorry, 31, my lord. 23rd April 2015. Promotional order. Sri Argho Mojumdar, Lower Division Assistant, initially bearing pay scale number 6 unrevised, is promoted temporarily with effect from 1/9/2014 to the post of Supervisor of Estate in pay scale number 9.
This is the promotion order.
Lordship.
No, this is 2015 order.
Yes, that is the promotion order. This is what he is challenging. He says that he got this.
He is not challenging this.
He is challenging the recovery.
He is challenging the recovery.
He is challenging the recovery.
Challenging
That is
not challenging.
that is correct. But this was given on temporary basis. And now
your sheet anchor is this 6821. 6821 nowhere says regarding recovery of things done in the past.
It says with effect from, we agree to create with effect from 1/8/2008.
Creation is with effect from 2008. Now they are conscious that others have been promoted, though there was no post. But they do still they don't say that you effect recovery from this person.
Pursuant to this, they write those letters to us. Firstly,
They may have.
and then they say you recover, and then the TR same.
Does not say anywhere regarding any recovery. It does not say anything about the past.
May I respectfully submit?
May kindly be approved. This is subject to approval of the cabinet. When was it approved?
My lord, it was to my instruction, my lord, it was not approved or not as yet been. What I have done is in my affidavit, my lord, at page 26, I have annexed, my lord, chapter 6 of the West Bengal Secretariat Manual. Page 26. My lord.
This is the rule of executive business.
Lordship, in the rules of business, we don't have. The state has. And Mr. Mukherjee has brought that. Kindly takes, my lord, chapter 6, 6.1, page 27.
If you know that it has no cabinet approval has not been given, why should we look into it?
No, my lord, it says decision on every case falling within the purview of the second schedule of the rule of business is taken with the approval of the cabinet. Now, my lord, second schedule, page 75. My lord, Mr. Mukherjee has.
The point is the order you are relying upon contemplates that it has to be approved by the cabinet.
My lord, I have
it cannot be exempted by you.
No, I respectfully submit.
You can't make such submission.
No. This is.
In fact, all this is for the state to submit.
Well,
How can you submit?
No, this all I am saying, my lord, this appears to be formal in nature.
How do you know?
No,
You have nothing to do with this order.
Second schedule, my lord.
You have nothing to do with this order.
No, I am the implementing.
Then
I have only.
How can you make submission with reference to this order? You cannot.
Page 75. The second schedule is at page 75.
Maybe we don't know.
It is there.
Maybe
No, second
even if we presume that such
Placement of.
even if we presume that approval is not required, the order contemplates it has to be approved.
Approved.
So can it be stopped from approval?
Government has approved it. Finance Minister has approved it and Finance Secretary.
It says subject to approval. That is a different thing. What we are saying is, where does this order say that where does it manifest any retrospectivity attached to this for the purposes of recovery? Any whisper regarding recovery on the basis of this order? You come to page 67. It says post to be created from 2008. It does not say any rectification steps to be taken to rectify the error or anything. Does it say anywhere? Page 67.
Paper 67. The number of persons post has been identified.
Correct. By now in 21, the government is knowing that they have wrongly been promoted. Because long before this, this issue has already been highlighted. So if the government wanted to say that recovery is required, it would have said.
Can you see? Geo number 1504 dated 27/85, read with dated 6/25, stand ratified on
Post facto basis. There is no retrospectivity. That is what we are saying. Yes. That is that we have pointed out this. It says post facto.
So can you see the
It does not say.
85 geo? Can you see?
Huh?
1985 geo.
1985?
Geo.
For what? For what? That doesn't mean anything. This is the basis on which the recovery is being made. Page 67, not on the basis of 85 geo. It nowhere says regarding it being any having any retrospective effect on the basis of which recovery is to be
If
made.
the number of post is not available, how could we give it?
We don't know. If the government wanted to rectify the thing, it would have done so.
Mistake has been committed. Whether government has the power to rectify the mistake.
Who is doubting? Have I said? Have I said? Have we said? Government can do it, government also cannot do it. So if the government wanted to do it, it would have done it. Government has not said to make any recovery. Government has only said you rectify the post. Nothing more. Any word regarding any consequential action being taken.
If there is no such post, can that promotion be given?
We don't know. That is something which was required to be decided.
Page 33. Page 33.
Page 33 is their order. That is not your order. Page 33 is not your order. You can't rely on page 33. You have to show us what is your decision. Where is your decision that a recovery has to be made from all the persons?
Recovery has to be made by the administrative authority.
Where is your decision regarding recovery?
No, but we can sanction the post. Recovery, what pay has to be given, that should be decided by the department.
So you have not directed. They have decided on their own.
No, we have only sanctioned the post.
Only sanctioned the post. And they are saying that you have directed. Just see the situation.
The judicial department's letters are there.
This is the circumstance.
They have said that you recover, which is possibly not seen that.
Can you see that?
How he can say when this order does not say anything? Judicial department.
Page 24.
Can you see page 24 of today's affidavit?
We have just seen.
24 for a moment. With the reverse paragraph, I'm directed to request you to furnish the following necessary document for taking further course of action from this end.
Yes.
Copy of the pages service book, all concerned staff showing entries, recovery of the persons already who are wrongly promoted. Report TR form number 7. TR form number 7, that means treasury channel.
Yes.
Refund of the government money.
They have sent the challan also.
Yes.
That was the direction. We had to.
That page 33 also.
Oh, receipt copy of TR form number.
That's the treasury challan.
Treasury channel.
Therefore, we asked him whether he wants to file anything, but he has said no. So he is not challenging these orders.
No, he has not.
But I only, in addition to what I have already submitted, in addition to that, I would simply request my lords to say whether this order can be said to exist. The order on the basis of which recovery and reversion has been made, whether this order can be said to exist, because it required cabinet approval and it has no retrospective effect. How could they affect it retrospectively? That is my only submission. I am repeating, at the cost of repetition, I am making this submission. Can it be said to exist at all? Because admittedly, no approval has been done. No approval.
Cabinet approval is not necessary under the second schedule.
Then why it is written?
No.
Subject to cabinet approval.
Formal approval.
Where is that formal?
Under the rules of business, second schedule.
Page 24 is annexure R5.
Maluk.
Where is the second schedule?
Page 75. Page 75.
Page?
75 of this, rule of this. rules.
Sorry, excuse me,
Just have it.
It is. So policy matters and senior officers.
And for the schedule
Where
one,
there is no financial concurrence, where there is a policy matter and for senior officers. Substantially the same in every state.
well, 163 is applicable all over India.
And you have said that others have voluntarily given this. You have given their letters also.
That page, the other names there,
Yes.
all those persons.
Their letter also you have annexed. Where they have said they have stepped down voluntarily.
But they have got the promotion.
Yes.
All have got the promotion, even including the petitioner. He's also serving in the promoted post now. Only the date shifted from 1st September 2014 to 1st September 2015.
Only.
Serving in the promoted post.
What the tribunal has finally decided. Let us
And that is that may not certified copy. I will.
Junior most incumbent in the post of supervisor. On campus. the judgment is ordered to the High Court administration. As soon as Gazette is published, also filed in Kerala High Court, or immediately for one copy to the Runner Advocate General, one copy to the Judges Library, one copy to the all the secretaries. High Court, High Court. Yes. English department. English department is there.
Probably, this is a very old book. This is a publication of 1964, I believe.
No. Time was amended. Time is amended. After the constitution came into force, then 1954 started. 160.
It is only available with the designated state advocate.
No.
It is not available in the market.
He is working on the judicial department.
This is just like Indian blueprint defense. This is not available in the market. This is only available with the designated state.
No.
But then
State
there is, but it's not available.
There are 4 places were there, but now only one place. 3 have been.
No, do we have near the High Court also? We have one state publication. They sell the gazettes and all.
But better.
Yes, so many state matters are governed by this. It is necessary.
State
But permission from the government is necessary.
Right. Nowadays, that should be done.
Normally we do take a printout from the books.
No, it is not.
Lordship. Only below haphazardly some portions are available in the PWD department's website. Nothing.
Anybody to publish because it should not be available to all of the public.
Lordship. এইটা নেই গো, কোথাও নেই। সেই জন্য তোমার একটু ফোন করি।
আমি যখনই দেখেছি কেউ প্রডিউস করেছে designated state.
That is the reason I called, personally requested Mr. Mukherjee on last Friday that I have required to place this before lordships. So he should get it from his client.
I'm grateful to him.
Good. Keep going.
Item number 11.
My Lord's judgment, I have handed over to Mr. Mukherjee. Your Lordship has this compassionate appointment shifting from mother to son, the application. To that effect, my Lord, after 16 years of continuous wait, my mother could not get the job. So I rely on the judgment of Arjun Kumar Soren. Yes. Exactly.
Yes.
To Mr. Mukherjee.
The Arjun Kumar judgment is not applicable in the facts of law. ratio of the judgment, because Arjun Kumar Soren applied, mother was applied, mother was selected, but before in the meantime, appointment could be given, mother died due to cancer. Then, this application should, the department said that the application could not be transferred. Said this is not a transfer.
Their mother was being processed. She said, I can't take it anymore. By the time the government still gave her the appointment order, she died.
I died.
So she had indicated that I'm not in good health. I cannot do it. So give it to my son.
Here also, my lord, same thing. She was found.
The first question is whether that order has been implemented or you have assailed it. We have wanted to know whether we are to go by that judgment.
So far, the ratio of the judgment is not applicable.
That comes later. We are asking you whether that judgment has been implemented or not. That is the question we asked you, whether it has been implemented or you have taken it further.
Whether I have been informed by the department that under process, whether SLP will be filed or not, because file is lying with the LRT for implementation.
Very well. Then we'll take it that it is not assailed. That means not assailed.
Exactly.
So how it is distinguishable from this case? In this case, the application was made on which date?
The date of death is 2nd October 1992.
2/10/92.
2nd October 1992.
Yes.
And mother applied on 15th February 1993.
Then
Then
when did she ask that her son should be considered?
that after 26th June 2006.
So by then she had not got the appointment.
Because there was no available vacancy of class group D staff.
Very well. So there may be some reason, we don't know, but she had not got the appointment.
Now, in 2006, she
14 years. For 13 years, she did not get the appointment. Then she gave a application that my son should be. Where is that application? At which
Page 49.
49.
What does she say?
She said, my lord, the prayer for providing employment to the post of Constable of West Bengal Police in respect of Tanay Mondal. This the petitioner, present petitioner before your lordship.
So what did
She
they
said,
do? What did they do on this application? We have read it.
my lord, yes, my lord, they have processed. My lord, if your lordship kindly takes up the affidavit in opposition, my lord, 3-man committee was formed. The 3-man
to look into your case.
Yes. They found me eligible, page 37, and they recommended my appointment. Page 37 of the affidavit in opposition.
So they have acted upon it.
Yes. And page 38 is the re-examination.
Page 38. No,
Yes.
this is the recommendation of
Yes, page 37. Last paragraph.
Page 37.
Of the opposition. Filed by the state.
Then what happened?
Then, my lord, page 38.
No, where is thereafter rejection must have been.
Yes, yes, thereafter. Page 38 also, my lord, this is a communication from the Director General and Inspector General Police West Bengal to the Assistant Secretary of the Government of West Bengal. Re-examination of compulsory appointment in respect of the petitioner. It has said that the candidate as the family is in need of immediate financial assistance. Page 38. Last
That's
part.
hardly relevant. Once the 3-member committee has said it, where is the scope for anyone to look into that? We are asking you what happened after that.
After the page 43,
Page 43, they have rejected.
Forward to the government. Government is at
Page?
page 43 of my opposition. 13 September 2024.
Let us take it up tomorrow morning.
Sorry, 9 September. Sorry, 9 September.
We'll take it up tomorrow morning.
Yes, tomorrow.
For further hearing.